Today we're going to be talking about probate and ways you can avoid probate. We're going to talk about the probate process, and there's a lot to it, so we wanted to dive into it with one of our local attorneys, Steve Walker. Steve, why don't you tell us a little bit about yourself, how long you've been doing this and where you come from?
Yeah, thanks for having me. Happy to share some time with you and some thoughts. So, Valley native, born in Calexico, raised in El Centro, been practicing law for somewhere north of 40 years. I do a lot of real estate, a lot of probate matters, represent several government agencies, and do a fair amount of litigation that lawyers do in a small town practice. So I tell young lawyers, yeah, you might make more money on the coast. It might be cooler weather, but the challenges and opportunities in Imperial County are just as good as anywhere else.
Yeah, absolutely. So when did you start working with probate? Was it immediate when you got the practice, or did you fall into it? Or?
No, it's I don't want to say I fell into it, but it's not an area of law that I ever saw myself practicing because it seemed so dull and dry.
Yeah.
But as I had clients with needs, and we started delving into them, trying to help them solve their problems, because that's what we're supposed to do at our best as professionals is help solve problems. I started doing cases, and then I started kind of liking the cases, and there's some kind of interesting questions out there. And then I really started wanting to help my clients figure out, we all want to make sure our stuff at the end, whenever that end is, gets to the people and the places we want it to get to. Unfortunately, I see too many times that people wait until the end of their life for end-of-the-life decisions that they really should be thinking about earlier on. So it's a great niche practice and pretty enjoyable.
Yeah, and I think, correct me if I'm wrong, but I believe down here there's a lot of probates that go on, right?
There are, for a number of reasons. And the probate process isn't something to be afraid of, right?
Yeah.
I mean, it's a legal tool, and it works, and it's under court supervision. The issue with probate process is it can be overly time-consuming, and it can be expensive for the parties. So if there's better ways to move your assets and your property to where you want it to go to, then that's where you ought to do. But a lot of people haven't thought about it.
Yeah.
And if they die without a trust or will or some other non-probate transfer kind of stuff, then the only thing their relatives, their heirs or sons and daughters can do is go through the probate process.
Yeah. And a lot of times, like in my industry, unfortunately, like you said, they come too late. And, I always go out there and tell the real estate community and try to tell the public to not wait until the last second. Because there are a few ways, right, that they can take care of it, sort of, if they are near the end. But a lot of times they end up calling a title company because, they feel, it's free to call them and maybe ask, the question. But I find that usually when they call us, it's already too late. It's, hey, my dad passed away. He was the only one on title. What do I need to do? And it's like,
that happens. And the other thing that happens more often than you would think is, John or Maria bring in mom or dad to do something with a will or a trust, and it's pretty obvious that they are not mentally competent because of age, because of mental disease, because of dementia, to make those kinds of decisions. And so you can't do that, and it's really too late at that point in time. I think what people don't think about it, there's lots of ways that don't require an attorney or professional to move your stuff.
Yeah.
You'd be surprised how many people on their bank accounts have not listed a beneficiary or a contingent beneficiary.
Yeah.
And that's a great way to make sure your money goes where you want it to go once you pass. I think some families make the mistake of just adding a son or daughter to an account to help manage finances. And that's okay as far as it goes.
Yeah.
But depending on how it's denominated, those people can actually be considered an owner of the account. So whatever problems they have in terms of judgments or liens can attach to that account. So you want to stay away from that if you can.
Yeah.
So financial institution accounts, retirement accounts, think about beneficiaries and doing it that way.
Yeah.
One of the things you can do with real estate in a limited fashion is for residential property, condos, I think it's maybe up to 4 units of apartments, and ag land if there's a house on less than 40 acres. California, like many other states, in the last 4 or 5 years has created something called a transfer on death deed.
Yeah, Todd, right?
And it's a document that a property owner can sign that says, when I pass, this goes to my son, my daughter, this charity. And it's notarized. And once the person passes, all you need is a certified copy of the death certificate. And you take it down to the county recorder office and you can get title changed.
Yeah.
It's not fit for every situation.
Yeah, true.
I know a lot of husbands and wives that have done it, but if it's property held in community property or joint tenancy with a right of survivorship, then it might be void or it might be delayed until the second person passes away, and we can certainly go more into that more if you want.
And Todd, I mean, so, you know, they created that, right, of course, to a simple probate in a sense for people, and I see it. The problem I do see, though, Steve, is I think inside it, right, and correct me if I'm wrong, but I believe there's some sort of noticing as well, right? As far as noticing the errors and stuff like that. Do you have to do that? Because I think they've kind of fell short if they do, because typically we'll get the TOD, and there's some things that have to happen with the TOD. You have to have, you know, 2 witnesses, for example.
Right.
Sometimes you get a notary, they don't really know. I mean, they're not there to be attorneys, and I get that. You know, we try to not get in your space either. We're not attorneys. But, you know, I've kind of seen that. So just walk us through a little bit of that, because I've seen it, at least on my end, where they've done it. And then I'm like, well, you know, did you notify the heirs or anybody else? And what are you talking about? Right? And then it's like, oh, well, yeah, I think we need to see that.
Yeah, so let's look at the 30,000 foot view. And every family is a little bit different. But when I do an estate plan, or could be as simple as just a will, or it could be as more complicated as a trust, or even with a transfer on death deed, I think it's best to tell your sons and daughters, your heirs, the beneficiaries, this is what I have planned. Maybe it's going to change in the future, because people can always change their mind. But this is how it is now, because a lot of problems occur after death of mom or dad, because someone thought the estate was going to go one way, and it didn't turn out that way. And so then you get into the whole probate litigation thing, which is a mess. It's a mess legally, and it's a mess for families. But under trust provisions, under transfer on death deeds, there's some noticing provisions to make sure people who are included as beneficiaries know what their rights are. And that's sort of what I've seen, you know, because people do it on their own, and that's just one of the areas where I seen it. They just kind of miss it, and, you know, we require that. That's something when you come to sell it, you know, you're getting in title and escrow, we're going to ask, okay, hey, do you have these notices? We're going to ask all those questions. Were there other errors, et cetera? We're going to need to see the TOD and make sure it was notarized, and were there 2 witnesses? And, you know, and like I said, unfortunately down here, you know, there's not too many even savvy, you know, notaries that, you know, and I know it's a panic mode. It usually is, right? It's like mom or dad, they're on their deathbed, and now it's, okay, we got to do something before they pass. So it's just going crazy, right? Like it's go, go, go. But, you know, what do you see on the TOD? I guess, you know, what would you tell somebody who's going to go down that route? Because, you know, I'm not negative on it, but I also am like, man, I know you can maybe do it on your own, but I always tell them, just have an attorney do this, because you guys do that as well, right? We do. You know, the great thing about the internet is you can find out a whole lot of information. Unfortunately, not all of it's right. But it's a great way to armor yourself with information, so you can ask the right questions of the right professional, right? So you get on a medical website because you're undergoing some healthcare thing. I think it's a great way to kind of figure out the questions to ask. I would never think of operating it on myself, you know. But, so I kind of feel that way with respect to legal documents that have a long time impact. Even if you don't want to have an attorney or a professional do the document for you, at least have them review it. perhaps you can save some money that way. But you've got a second set of eyes doing it.
Yeah.
I mean,
somebody
simple-
knows what they're doing, right?
I mean, I'm not a tax professional.
Yeah.
Could I do a simple tax return? I absolutely could.
Yeah.
But I don't do my own, right? And I'll sketch it out, and then I send it professional to make sure that I've got all the right deductions,
Yeah.
or I haven't missed something, right? Because you want to make sure you have the right information.
Yeah, yeah.
going in.
And so many people do it. You're right. I mean, they do it on their own, and it's an urgent matter, so they've heard about it. They go do it. And sometimes, it's not, it's just a misconception. They're like, oh, I thought I was good. And then once we get into the nuts and bolts of it, it's like, well, this wasn't correct, or did you notify them? Also, I believe there's a provision that they can't sell it for, I think, 120 days. Is that right? On the TODs, like if somebody were to pass, because it seems like once, the loved one passes, they're like, okay, we want to sell it. And then they're coming into escrow, but there's still I think there's a waiting period in there, right?
I'm going to confess my ignorance because I really haven't looked at that part of it.
I think there is.
It would not surprise me if the legislature put something like that in there.
Yeah.
And getting back to kind of what we started when someone comes in, wants mom or dad to sign this because they're on their deathbed.
Yeah.
Fast decisions are rarely good decisions,
Yeah,
right?
very true.
And I'm not suggesting that someone who's in the hospital or someone who's got a debilitating disease cannot execute a legally valid binding document. But you just want to make sure that those folks are competent to do it.
Yeah.
And then you've got some witnesses there that are disinterested, not somebody else who might be inheriting.
So it can't be the son then, right? Who would, sitting there saying,
who'd be willing to testify in court later on. Oh yeah, I saw Mr. Jones sign this, and he knew what he was doing because I asked him and he said so. So those are the kinds of things you really need to think about. Because it always comes up in probate and trust litigation as well. Yeah, mom or dad signed that, and John's going to get it, but she didn't know what she was doing. She was sick. She'd been seeing a doctor.
Yikes.
I mean, that's the standard kind of pleading.
Yeah. And when they do, because I've run across that as well, whenever they do have some mental acuity issues, can they still execute the document, or how does it work if there is that in play?
I mean, they need to be competent as a time and space, right?
Gotcha.
They need to know where they are. They need to know who they are. And they need to know the date and time. And if they can remember who the president is, that's great.
Yeah.
More importantly, they need to understand the significance of the document they're signing. And,
Gotcha.
and it needs to have been explained to them.
Yeah.
And some kind of indication that, yes, that is what they want to do.
Yeah.
It may not necessarily have to be a verbal indication. It could be a nod of the head as long as everybody's agreeable. But I mean, I think we all know when people are.
Yeah, and that's sort of what the notary is there too. If they use a reputable notary, and that's sort of in our field, that's what we would like to see and know who that notary is, to feel more comfortable, because those are exactly the questions we ask, even if it were either our notary or a notary that's an independent that we don't work with. We're going to call, we're going to get them to say maybe even a statement of facts, like, hey, were they in their right mind when signing a document, sort of a third party, somebody who's not tied to it, in order for us to feel comfortable with, okay, the TOD specifically, okay, we're comfortable insuring and moving forward with it, right?
So if, in the event of, I don't want to scare people away from it.
Yeah.
But if a legal issue does come up, I can promise you that the witnesses to the will or to the transfer on death deed or to the trust, including the notary, are going to be the first people called to the stand and talk about whether or not this person had the mental acuity to sign what they're doing. Did they know what they're doing at the time?
Yeah. Another thing I wanted to ask you about, Steve, was a couple years ago, we had that small value property affidavit, right? And it was another one of those simple probate options for clients, and it was really, it was for really low. Not too many properties could be included or go that route, because it was like 187 total asset, right?
Well, before that, it started at about 66.5, and so there was hardly anything that was going to qualify in terms of real property.
No.
You could still use it for personal property and assets, but jumping ahead to what I think your question is, the legislature's done a good job, and I think for deaths after August of 2024.
Yeah, it's fairly new.
The value is now up to $750,000. So that covers a lot of real property, residential homes in Imperial Valley that allow you to, with a simplified petition, certain people can file it. Has to be heirs. 40 days have to have elapsed. Has to be appraised by the probate referee to make sure it's under that threshold. And then after a court hearing, it's pretty much
done deal.
Pretty much done.
And
you don't have to pay the statutory fees for an executor. You don't have to pay the statutory fees for an attorney. And those, for those who may not know, those are all based upon the size of the value of the estate. So the bigger the value of the estate, the bigger the percentage an executor or administrator can take, and it's the same value for attorneys, which is why it gets to be too expensive sometimes.
Oh, gotcha. And it's not only includes property, you could also include other things in there, right? Like stock, stuff like that. Because a lot of people don't. I mean, when it comes to property, we can, recommend it sometimes.
There's a couple different things. The one is a petition for succession to real property, which has that higher value. Then there's some things called, there's a spousal property set aside for a widow or a widower. There's a small estate set aside that has different values. But there's some simplified probate mechanism that people can use without having to have a full probate if they don't have to.
Yeah, if they don't have to. Yeah, so California, we'll give them one, right? I know they don't always get things right, but I think with that one, they did a pretty good job about at least allowing people, if it's pretty simple, to go ahead and go that route, and then that way they save a little bit on money, right? And you guys help in that space, though,
we
too,
do help.
right?
We help. We prepare those things, and we help people go forward. There is an access center at the local courthouse where people can get some assistance with those kinds of things. Not every one of them, but there's a lot of people in probate court on Friday mornings that don't have an attorney, and they're able to figure it out. It takes them a while, but they're able to figure it out.
Yeah, I mean, and that's the thing with those types. It all depends on the situation, what the client's trying to do. If it's just pretty simple in the sense of, hey, the property, we're worried about that and getting it into whoever's hands, and we're all agreeing and it's all good, they can go that route. But where the rubber meets the road usually is in those documents, because I've gone online and they got all kinds of different ones, right, on the internet,
right? And
some places are free, some they charge you. But you're saying they could actually go down to the probate area here and get these documents.
Well, there's two great resources. So one is the Judicial Council of California, which is they oversee all the state court system. They have a great website. It's very interactive, and you can kind of pick the area of law you want, kind of find the form you want, and for many of them, there's descriptions about what has to be filed, when you have to file it, who has to be served. So it can be very helpful for somebody who can't afford an attorney, who doesn't want to use an attorney. So that's always a good starting point. And then armed with that information, the Imperial County Courthouse, as do most courthouses, has what's called an access center down in the basement. And for some certain areas of law, probate, conservatorships, guardianships, family law, there's a research attorney that will kind of help you, depending on what you're asking for. But will help you kind of
guide you a little bit with the document. Yeah, because they can be confusing, right? I mean, I see them, but to the average person, they get it, and it's like, I don't know how to fill that out. Well, talk to an attorney. But tell us a little bit about an actual probate process, like when people should call an attorney, and then sort of how it works, because a lot of people come to us first, like I said, and they're like, well, what's the process? Well, it all depends, right? You know that. But.
So there's as we touched on a little bit. There's a lot of areas, a lot of mechanisms where you don't need to go to probate. I mean, shouldn't be afraid of probate, but it really ought to be kind of the last alternative in somebody's estate plan. Yeah. So the typical probate process starts with someone, usually a family member, doesn't have to be, but someone with an interest in. They file a petition with the Superior Court. If there is a will, that will has to be lodged with the court. If there is not a will, that has to be noted on the form. They've got to list all the assets that they know of, whether it's real property or personal property or
Cars,
watches,
stuff like that,
jewelry,
yeah.
all that kind of stuff, because that determines the value of the estate. And those values, for the most part, are determined by a state employee called a probate referee. And every county has a probate referee. And
we have one, right?
We have one.
We only have one
for our county.
So that's sort of, another thing that I'm glad you mentioned, with the process, right? Because people go, well, oh gosh, the process is so long. Well, sometimes it's because we just have one probate referee, right?
Well, that's one of them.
Yeah.
One of the reasons, right? Because you have one probate referee who has to appraise the property.
Yeah.
And sometimes they're physically looking at the property, but sometimes I've been able to send them pictures of the property or a schematic, and they're able to do it that way. And so there's time built into that process.
Yeah.
The other thing that's built into the process is creditors of the estate, people who think that person might owe them money, have to have notice that this probate's been open. And so you've got to publish the filing of the petition in a newspaper of general jurisdiction. And that's any of them down here: Calexico Chronicle, Hopewell Tribune, Imperial Valley Press. And then those creditors have 90 to 120 days to file their claim.
Gotcha.
And then one of the jobs of the administrators is to decide, yeah, that's a valid claim. No, that's not a valid claim. And there can be litigation over whether or not a claim is valid or not, or whether it's timely or not.
Yeah.
And then the administrator or the executor, and the difference is if there's a will, there's an executor named in the will, and so that person is in charge of making sure the probate gets done. If there's no will, then that person's called the administrator.
Yeah.
The duties are the same. Marshal the assets, find out what's there, find out if taxes have to be paid, inventory everything, let the court know what there is in the estate, pay the claims that are valid, and at the end of the process, and I'm abbreviating, at the end of the process, it could be as quick as 6 or 7 or 8 months. That would be very quick, but it's usually a year and a half on average.
Gotcha.
In our office. Then you tell the court, we're ready to close this estate. Here's the stuff we brought in. Here's the bills that have been paid. The taxes has been paid. This is what's left, and this is where it goes to. And then the court has a hearing and blesses that. And then the last job of the administrator or executor before their discharge is to make sure the stuff gets where it's going.
Yeah.
You mentioned cars. Cars don't necessarily have to be probated, right? So as long as someone has a will or something indicating they're next of a kin, there's a form on the DMV website that you can take in the DMV and get title changed.
Okay.
And it's usually pretty straightforward if they can figure out that you're your person, that's entitled to it. I'm finding more and more financial institutions, though, if someone's not listed on an account, they want some sort of court proceeding. They're not.
Oh, really?
They're not just allowing you to file a claim.
File a claim anymore?
We were able to do that years ago, where we could show these were the only heirs, and everybody's in agreement this is the only heirs. And, and the bank would write a check to everybody, but they don't do that much.
They
anymore.
don't do it anymore. Huh?
Yeah.
So even if like, let's say there's 2 heirs, like me and my brother. My mom passes away. She was the only one, and we didn't take care of anything. Sure enough, she's on title, and that's it. The probate process, even if we were to agree, it's still going to take about 6 months, 8 months, even if it's like pretty simple, pretty slam dunk.
Depends on what's in the estate.
Okay. Yeah. But it's really how much is in the estate to time-wise, right?
And what's the condition of the estate? Has someone have a bunch of farm ground that they haven't paid taxes on, or they've got existing leases, or those kinds of problems delay the process a lot. So if there's a will, then it's clear who the beneficiaries are because they're usually named in the will. If there's not a will, then the state of California tells the probate court where this stuff goes, and typically it goes to heirs like sons and daughters, and if there's no sons and daughters, then it can go laterally to brothers and sisters, or I think in the first instance it goes up to parents if they're surviving, and then the brothers and sisters, and then kind of trickles down that way.
Okay.
Which is why you should think about your estate plan and where you want stuff to go. Otherwise, the state of California will tell you where it's going to go, and maybe it's going to go to your favorite aunt, and maybe it's going to go to that brother you don't like.
Yeah. Well, I always recommend, and at least on the title side, and probably on your side, you guys do trust, but trust is the best thing you can have, for your assets. Like you said, some stuff I learned recently from a local attorney, which I had no idea, but when we have inter families or me with my kids, and then I remarry, and now I got, 2 stepchildren or whatnot. Well, you can disinherit people, right? I didn't know that. It's like, hey, maybe I don't even like, one of my sons, and I'm like, you're not getting any of a dime. You can disinherit that way because, I guess, when they, in this scenario, they got married, and one of the stepsons, well, he got more than the actual son because the actual son got disinherited, right? So it's pretty interesting when it comes to that. But yeah, trust is obviously, right, the best to do.
Yeah, well, and you bring up a great point, Andre, because one of the things that people do is they'll create an estate plan, whatever that looks like.
Yeah.
Oftentimes with a trust, and then they'll put it on the shelf and they won't ever look at it.
Mm-hmm.
But their life changes, their family composition changes, and so their intentions about their estate may change.
Yeah.
If I want my daughter or want my son to have my Rolex watch, if I had a Rolex watch, well, what if I don't have a Rolex watch? Does that mean my son or daughter doesn't get anything, or does it mean they get something else? So you need to pull those things off the shelf and go through them every couple of years to make sure they comply with what you want to have done.
Yeah. Oh yeah, exactly. And it's pretty ironclad, right? When you do a trust, you can amend it and stuff like that. Some people have asked me that, like, oh, well, if I create it and something changes, can I amend it? Yeah, you can amend it, and talk to your attorney. And there's different types of trust. So it really just depends on, right, what they're, because I run into that. What's the difference, Jamie? And I'm like, well, ask an attorney. I'm not an attorney. But, we got an irrevocable. We got a living trust. We got, how many trusts are there?
Really, the two basic type are revocable and irrevocable. And irrevocable is once it's signed and executed and funded, it's set in stone and it can't be changed ever.
Gotcha.
There are reasons, including tax reasons, where people want to do that. Most people have a revocable trust that they're able to change.
Modify.
They're able to fund, they're able to put stuff in, they're able to take stuff out.
Yeah.
And it's not set in concrete until that person passes away. If you have a family trust, mom and dad have created a family trust, and then depending on the language of the trust, let's say dad passes away, mom can still change it. Some of dad's provisions may be set in stone, but not always. And it just depends on how it's drafted for you. But once the second person in the family trust passes away, then it's set in stone.
Gotcha.
And for the most part, can't be changed.
Gotcha.
And it can't be added to.
Can be.
There's some exceptions where the court has authority to add stuff to a trust even after somebody has passed away.
Gotcha.
So, for example, someone has all of their assets in a trust, and they just acquire a new piece of property, and they start going through the motions, but they haven't quite got it into the trust, and then they die unexpectedly. So they've got this new asset that's not in a trust, and everything else is in a trust. Under those conditions, the court will often say, you know what, it was the intention of this person, based upon his entire estate plan, to have this in a trust, and we're going to allow it to pass under the trust instead of having gone through probate.
So the trustees, like when you have the trustees of the trust, usually the kids, right? If you're doing the family one, they can't modify it after mom and or dad are both deceased, kind of locked in.
So the initial trustees are in a family trust. We've done mom and dad.
Yeah.
And they're able to change it up until the point in time that they pass. But once they pass, then whoever they've designated as successor trustees, their obligation is to make sure that the trust is essentially wound up.
Gotcha.
And stuff distributed like mom and dad would want it to be.
So then it just pretty much everything gets distributed and it's a done deal. It can't continue on and like they can't just keep it in that trust.
There are some. Well, one reason why a trust might continue after somebody's death is, for example, they've set up educational funding for grandkids, and those grandkids are going to get that not all in one lump sum when they're 18, but they're going to get some at 18, some at 25, some at 30.
Yeah.
So that trust has to stay open do that kind of thing.
Yeah.
And then there's other trusts that are set up to help kids or grandkids with special needs that have not a perpetual existence, but an existence beyond the life of the person who created it.
Yeah. So one of the things I wanted to ask you, Steve, is when it comes to will, right? Because I always make a joke and do some of my videos. I hold up a napkin and I put, will.
Mm-hmm.
I mean, have you experienced that? Have you ever had where they bring a will? Is it acceptable if it's just written on, I don't know, a napkin or even something crazy like
So
that?
California is one of the states that allows what's called a holographic will.
Mm-hmm.
So the requirements of a holographic will, it has to be entirely in the person's handwriting, and it's got to be witnessed by at least 2 people.
Okay.
And that's pretty much it. And as long as
You have
that's
that?
complied with, then it's a valid will. And yeah, I've had cases where that's exactly been the case.
No kidding, huh?
Yeah.
On a napkin or on what?
Just on a piece of 8.5 by 11
No
paper.
kidding,
yeah,
huh?
yeah.
Boom, boom, boom. That's so crazy.
Yeah.
Yeah, I had heard that. I just didn't know if it was 100% true, but we've had people come in with sort of, hey, and it's all crumpled up, and I'm like, I don't know, take it to an attorney.
In my office, we always have the conversation about let's try and avoid the probate process if we can. So,
Yeah.
what's your state look like, and let's kind of strategize what that might look like.
Yeah.
Some people only want to have a will, though, which is fine because it does, as long as it sets forth what we call them the testator, the person's intent are, then you've got something you can take to court, right?
Yeah, sure.
How would something like that come into play? So one of the things that happens a lot down here in our community is an eldest son or daughter will be added to a bank account. We talked about that a little earlier ago. And it's typically not because they're going to be the owner of the account, but because they're going to help an elderly mom or dad manage their
Bills,
financial affairs and things like that.
Mm-hmm.
And with the understanding that, okay, when dad passes, then I want that money to be split 4 or 5 ways depending on how the kids are.
Mm-hmm.
Sometimes the child on that bank account gets memory lapse about what mom and dad might want to have happen and treat it as their own account. And then it creates obviously problems within the family, creates problems legally.
Pass, yeah. Mm-hmm.
But you could have that in a situation if you want it. I don't advise it. But if you're going to do that, I would say have a will that sets forth why this person's been added to the account and what's supposed to happen with the money in that account once they pass.
Once they pass, yeah. All right, so Steve, another thing that I learned and fairly new is with the trust, and when it comes to selling it, when the kids, the trustees, they have it, and then they go to sell the property down the line, is the step-up basis when it comes to taxes. Can you just elaborate a little bit on the benefits of that?
Sure, I won't qualify my answer by saying I'm not a tax attorney.
There you go.
But I do know how this works, and we were kind of talking offline about the wisdom of adding a child to the title to your house, and I almost always advise against it, just because that child's problems, if she has any, just can end up attaching to the house,
property,
and there's no good reason for doing it. There's other ways to do it. We have a trust or transfer on death deed. The recipient, upon the death of mom or dad, is going to receive what's called, first of all, it's not going to be recessed for property tax purposes, because it's an inheritance from your parents. That's one of the exclusions. So you're getting the same property tax. And then you have what's called a stepped-up basis. So you get your let's say it's your parents' trust and you're inheriting on the parents' trust, you get their fair market value basis in the property when you acquire it. So you're not paying capital gains on that at the time you acquire it. You will pay capital gains on the difference between that stepped-up basis and fair market value if and when you sell it. So the closer you sell it after you inherit it, it's probably a wash.
Yeah.
But obviously property taxes go up and you keep it, but you're still only paying the difference between your folks' fair market value. So if they bought a home at $100,000 and then 20 years later it's worth $450,000. You inherited at the $450,000 basis.
Yeah.
And only have to pay capital gains on the difference between $450 and whatever the sell price
Whatever it
is.
is, yeah.
So
Instead of 100 to
a
that.
lot of benefits to setting up a trust, and that's just one of them.
Yeah, and we were kind of talking offline about adding people to title, whether it be a kid and whatnot, and you advise against it, and it does create problems, and I see that on the title end a lot. Example that I gave was whenever you just don't know, right? Your kid's not going to tell you that maybe they have a credit card that they haven't been paying, or they're swimming in debt, and that'll attach to the property. So if they add one of the kids, and then even if they take them off, right? They were on it. If those judgments, any sort of lien against them, money judgments, etc., they're going to attach if they were filed during that time when they were on ownership. So, just he advises against it. I do as well. I mean, again, you can add somebody, but I would just say you better know for sure what's going on with your kid, and they're not going to tell you usually, hey, I'm not paying this, or I have all this, Dad, don't add me to the title, right?
Yeah, and if you got a great relationship with that son or daughter when you add them to title, and you want to change that later on, if they decided to change their mind, then you're not getting them off title.
You're not getting them off title.
They're an owner.
Yeah, they're not an owner.
So I think one of the things people should have, we all have an emotional attachment to our family home, the home we grew up in, right? And so you often see mom and dad putting all the kids on title to the house.
Yeah.
Okay?
Down here we do,
that's just a different set of problems because now you've got 3 or 4 or 5 people who are now co-owners who may not agree on what's supposed to happen to that house. Yeah. Some may want to keep it, some may want to rent it out, some may want to sell it, maybe someone wants to buy it. And if they can't agree, your only recourse is to go to court and have the court order it sold and proceeds split.
Gotcha.
So in that kind of case, I think you have to read the room with your family and figure out, well, maybe we're not going to leave the house to all 5 children. Maybe we're going to have the trustee under the trust sell it and the proceeds split, and then you avoid all that problem.
You avoid all that.
There could be a mechanism for someone to buy it if they want to, but
like one of the kids, you mean, like if they were wanting to purchase it. Yeah, and they, when it comes to that, that's been coming up a little bit more too on my end, on the title side of things, because we're getting that where there might be 3 siblings, and 2 want to sell, 1 doesn't. So then it's like, well, what are you going to do? And then what you talk, I guess it's like considered a forced sale, right? Like you're going to do.
It's called the partition action.
Partition action.
And if it's a single, I mean, it's real easy if there's 2 people and there's 2 40-acre parcels, right? Where you take parcel A and I'll take parcel B. But if it's a house, you can't split it up that way. So the only thing the court can do is order it to be sold, and that's what the court will do. And that's an expensive proposition.
Yeah, so then you got to go through that just to say we're selling, and you're going to do it. Now, when they do that, does the court, if one of them is totally against it, doesn't want to sign, does the court kind of act on their behalf to say, or do they just force them, you're selling?
The law does not require people to co-own property with anybody else. So the fact that they don't want to sell is of no import. The court's going to order it sold. That's all it can do.
That's all they can do. Okay, and then they got to pick up the pieces from there. And then another thing that we'll just talk about real quick, and Steve hit on it a little bit, is when it comes to property taxes, right? And you've disclosed, and neither am I. I'm not a certified tax person, but we deal with this quite often, so we can talk a little bit about it. But what Steve mentioned with the step-up basis and with the property tax, and you get that a lot now, even, right? That people don't realize. But if they gift it, let's say, I'm going to gift it to whoever, their son, their daughter. If they don't do, there is an exclusion in the property tax code that you can use, but a lot of people don't know. They don't fill it out right because they're doing it themselves, right? They're trying to save a buck. They don't go to a professional. And what happens is it gets reassessed, right? So that if you have a low-value property that's been in the family for 20 years, it was bought at $120,000, now it's worth $450,000, you better believe the county assessor is going to go back and say, hey, it's worth $450,000. And now your tax liability, or your property taxes are just shot through the roof. And on top of that, you're going to get supplementals, right?
Yeah,
it's tough.
Which is why it's easy to add somebody to the property. It's easy to create the deed. It's easy to have the signature. It's easy to get it notarized. Easy to get it recorded.
Oh, yeah.
But it can have significant impact
Absolutely.
on the value of the house,
Yeah.
on capital gains,
Capital
on
gains.
reassessment for property taxes. So
Yeah.
you need to think long and hard about that and ask the right questions of the right people.
Yeah, absolutely, absolutely. So, yeah, we wanted to mention that because I see that quite often. I was talking to the assessors, and he wanted me to tell that to the community, not only the real estate agents, but to you guys as homeowners, etc. Just be careful because that too many people have been hit with it, and you only have 30 days. If it's a parent-child transfer, you only have a short window for them to say, hey, this transfer was between parent and child. It's excluded. Don't hit us. And if you don't, you're out of luck. You're going to be paying for it. So good information. Good information. Absolutely. What else do you kind of run into a lot down here, Steve? I mean, you just mentioned one where they're doing that, but is there anything else that you see just kind of a valley thing where you're like, oh, I see this quite often?
So
Too many to think of.
yeah, I mean, what happens not infrequently?
Yeah.
That results in not only people getting their nose out of whack, but litigation is a son or daughter moves in with only mom or dad, takes care of them, may take money out of their own pocket to help pay for expenses and stuff like that, and then when mom or dad passes, there's heated discussions about, well, should that person get a bigger piece of the estate, a bigger piece of the pie, because of all the work that they put in caring for mom and dad, when the other siblings or relatives didn't do that?
Yeah.
I mean, that's a family dynamic, but it happens all the time.
Yeah.
And so I think, I think parents, particularly in that situation, I see them putting that child on title to the house, as an owner, and then even if the plan had been
to include the others,
talking at family discussions over the years that this house belongs to all you kids and I want you all to share in it equally, right? But if only one of them's on title to the house, then it creates a problem legally.
Yeah. And when that happens, is there any kind of legal recourse that they can take? Like, are the other kids, let's say, I'll use an example with my brother. Let's say he's he's with them financially, he gets the bank account, and my mom's like, when I pass, you're both going to get it. And he goes and he gets added the title. I don't realize it. She passes away, and I'm like, all right, hey, we're going to sell the house and chop it up. And he goes, no, I already sold, I'm selling the house and you're getting
nothing. Yeah. So what I would have asked the court to do in those kinds of situations is look at the totality of the circumstances. Did Bill or Mary, when they moved in with mom and dad, and were put on title, did they pay the property taxes or a portion of the property taxes? Did they pay upkeep and maintenance? Did they pay any of those kinds of things? And to the extent that they did, I think they have an argument that they're more like an owner than anything else.
Okay.
But if they're, and I'm not minimizing caregiving, but if they're only there as a caregiver, and it's not their money in the bank account, then they look less like an owner of either the bank account or the house, and more like,
caregiver, more caregiver,
just a caregiver, right?
Yeah, just there. Gotcha. And I haven't heard, but have you run across that where let's say that was the case, and then they went and sold the house, spent the money? Is there any kind of recourse for that person to come back? It would just go into litigation, I guess, at that point.
It would go into litigation, and we've had cases exactly like that.
Really? Yeah.
Exactly like that.
Yeah. And unfortunately, down here, what I hear too, Steve, is sort of the caregiver, because you mentioned is that's the case. Like, family might be around or maybe not around. Maybe they're, living in a different area, and then you have a designated caregiver. And, they kind of weasel their way in, and they get on the bank account, and they're spending the money, and they're trying to get them maybe even to sign a deed over for the property. We've run across some of those cases, unfortunately. And, we also will look at a little bit on intent too. But sort of the heirs or the kids, they kind of got to bring that up too, right? It's like, we're just looking at documents unless somebody comes and says, wait a minute, this is all fouled up. Take the legal course action to get it done, or stall the sale, for example. That's how you do it. But I've heard it, and I've kind of seen a time or two where thankfully it hasn't gone to a sale, right, with us, because then that would, I'm sure, bring a whole legal battle between everybody and we're getting dragged in. But, you know, I'm sure it's happened. I'm sure it's happened where it's gone that far.
It happens more often than you thought. And it kind of gets back to what I alluded to at the very start of this. I mean, we wait too long often to make end-of-life decisions until the end of life, and we should be having them sooner. And they shouldn't be uncomfortable decisions to have. I mean, no one wants to talk about with their mom and dad about the time when they're not going to be around there.
Yeah.
But it's an important conversation to have, and it's an important conversation to have from time to time. And mom and dad really need to make clear what their wishes are, and that's kind of the problem sometimes. Not that necessarily they're playing favorites, but they don't want to appear to be playing favorites, and you know, sometimes mom says, "Well, you're going to get my diamond jewelry." Daughter one, and you know, 2 weeks later, tells daughter two she's going to get it, and so you have those issues. So it avoids a whole lot of problems within families and within the process if people are clear on their intention. As much as they can be specific.
Yeah, you know, when it comes to the simple estate planning, whenever, you know, I get in a conversation with either a client or maybe even somebody calling, you know, there's still always the change of circumstance, because what I see on my side is, for example, you know, intent, maybe they got one kid, right? Okay, great. I'm going to do some simple estate planning. I'm going to add, you know, my son as a joint tenant. And when I pass, he gets it. We're good to go, right? But it always seems like things change. You know, rarely do I actually see it go through that way. You know, we had one where guy did that, and then he's decided, and, you know, son ends up getting married. You know, he's on title for 3, 4, or 5 years. And then the father ends up saying, you know what, I'm going to sell. I'm going to ride off into the sunset. I'll give you some money, son, but, you know, I'm going to relocate, and I'm going to live out the rest of my life. Okay, you know, son was on board. Problem, though, he's married.
Right.
And now the wife is going to be a soon-to-be ex-wife, and she doesn't want to sign off on it. And she thinks she's entitled to some money. But then it causes problems. And there's other issues, right? You always got to be careful. I always tell people, like, you know, you can do the simple estate planning, but from my experience, you know, go trust, you know, and they're really, you know, I started one, I didn't quite finish it, but it goes into depth, man. I mean, I don't think people realize just how much you're going to talk about inside building a trust. It's like, okay, hey, mom, where you want to be buried? Or do you want to be cremated? You know, so you're going to get in a lot of these discussions, but it's better to have it, because if not, you're going to go through the probate process. If there's infighting with the family, it's going to be a longer process, right? It's going to cost a lot more money. How much is it, more or less? I know it all depends on circumstance, you know, when it comes to trust, if you're got a ton of assets or simple assets. What sort of, you know, give people an idea about what a trust sort of would cost on average?
I think the market down here, and I'm not sure there's a simple trust but for a basic trust, it's probably going to be between $2,000 and $3,500, depending on something else that might, you know, how it's funded, what are the properties going to be in there, and what the specific terms and provisions are going to be. And
how much is a probate usually run?
Let's say your asset, your only asset is a house, and that house is worth $200,000. Then both the executor and the attorney that's hired by the executor are going to get 4% of the first 100,000, 3% of the next 100,000. So you're in it for 7,500 times two. If my math is correct.
Yeah.
You know, for a couple $100,000 house. So used to have a very experienced attorney tell me that she really thought you could pay it at the end in probate, or you can pay it at the front end in the trust, and it's kind of a wash. I don't think so. I think it's much more economical on the front end, and you get to make the decisions. And you're not leaving it up to somebody else to make the decision.
Yeah, and, you know, it's just sort of a misconception. You know, a lot of people think that trusts are for rich people. You know, oh, well, it's rich people. But you just stated it's literally less expensive if you're to create a trust, get all your ducks in a row before, than to actually go through it. And you know,
Yeah, I think most of us want to make it as painless as possible for those we leave behind, right?
Yeah.
I think I've had one client over the years say, "Nope, I'm just gonna leave a will. They
can figure it out.
It's their problem. I'm not gonna be here.
I'm not going to be here.
But for the most part, everybody wants to make it as painless
Easy.
as possible and easy as possible.
Yeah, no, absolutely. Well, Steve, I appreciate your time today and giving us some insight on probate and everything involved, the cost, et And how can people reach out to you, Steve? Let them know, where you're at and how they can reach out to you if they got to go through the probate process or even set up a trust.
Well, you can Google me. The firm
There
is
you go.
Walker and Driscoll, and the phone number is 760-352-4001. You can find me Friday in probate court and at Starbucks on Imperial Avenue about 11 o'clock on Friday mornings.
Awesome, man. Well, good deal. I appreciate your time, man.
Hey, it was fun. I appreciate it.
Yeah, awesome. Cool.